Welcome to Unit 5, Medical Law and Ethics, HC310, Herzing University Online. In this unit, we will cover HIV, AIDS, ARC, mandatory reporting and confidentiality, and discovery and admissibility of medical records in a court of law. Behavioral objectives. We would like you to outline statutory regulatory requirements for mandatory reporting of HIV and AIDS cases to state and local health departments. We'd like you to describe statutory provisions allowing disclosure of HIV/AIDS information pursuant to a court order, and give examples of how courts might respond to petitions for such orders. Explain the limits on disclosure of HIV/AIDS test results of the patient in circumstances where exceptions apply and of the healthcare provider. Behavioral objectives continued. You should also be able to describe the healthcare provider's role in protecting health information from discovery. You should be able to define hearsay. You should be able to recommend steps to protect peer review records from discovery. And finally, you should be able to outline the factors that affect whether incident reports are protected from discovery or not. Overall, we should remember that all state laws and statutes should be checked first to see if they apply in the case in question. As noted before, throughout this book, reporting laws and regulations vary widely from state to state. HIPAA always preempts state laws if its protection is greater than that of the state law. Conversely, or otherwise, the state laws preempt HIPAA if the protection is greater than what HIPAA might provide in the specific case. Remember these guidelines throughout the course. Duty to report. Duty to report is a practice standard by which a health care professional is required to report any unsafe practice or professional misconduct. This duty to report is a professional, ethical, and legal responsibility. Duty to report related to HIV/AIDS is a complex issue that centers around the volatile issues of the means of transmission of HIV. The issue is further muddied by legal liability issues in terms of reporting. All states must report AIDS cases to the Centers for Disease Control and Prevention, or CDC, by law. States may individually have their own special confidentiality statutes which govern the disclosure of AIDS-related personal health information, or PHI. All states have statutes that require care providers to report AIDS-related cases to their local public health departments, PHD. States may also require the reporting of HIV and/or AIDS-related complex, ARC, as well. Duty to report continued. Your individual state laws will determine the type of information that must be reported, and may vary from full disclosure to minimal amounts of information that are used for epidemiological purposes. Mandatory disclosure for laboratories and physicians within a set amount of days is noted in most states. Protecting confidentiality of HIV-related information. The Privacy and Security Rule. The general rule states that a covered entity may not disclose personal health information, PHI, unless there is an authorized disclosure in writing or the privacy rule itself permits the disclosure. Information created in a blind HIV test without patient identifiers in it is not considered PHI or personal health information for the purposes of the privacy rule. Protecting HIV-related information is challenging for covered entities who deal with HIV or AIDS information. Since state laws vary and may or may not preempt HIPAA, following the appropriate legislation may take consultation with legal experts. HIV/AIDS personal health information also requires the security safeguards in the security rule. Protecting confidentiality of HIV-related information continued. State laws control the use and disclosure of HIV or AIDS-related information in covered entities, not non-covered entities, if the following occurs. The state law is less strict than HIPAA and therefore not preempted by HIPAA. The organization or entity itself is not subject to HIPAA. Confidentiality statutes provide that no person may disclose the identity of HIV test subjects, test results, or the status of the patient. Any recording of the test results must protect the confidentiality of the person's identity. Statutory provisions regarding disclosure. There are a number of disclosures permitted under the privacy rule. For instance, disclosure is allowed if the information will be necessary to prevent a threat to the health and safety of the population or a person. As an example, a physician may disclose AIDS HIV status of a patient to personnel who would be working with the patient on an invasive procedure where they may be exposed to bodily fluids. Covered entities should always comply with state statutes if not preempted by HIPAA. Statutory provisions regarding disclosure. Disclosure of HIV/AIDS status may be disclosed in writing to third parties with the authorization of the patient. Disclosure to healthcare workers is permitted under the privacy rule if the disclosure is for the purpose of treating the patient. The status of the patient may also be released to the medical provider who places the results of the HIV test in the patient's record. Disclosure may also be made in some states if the person providing the care has a reasonable need to know in order to provide proper care to the patient. Statutory provisions regarding disclosure. Disclosure in some states may also be made without the consent of the patient or emergency medical personnel. This is rationalized as being for either the health of the patient or the health of the worker. Some states may also have a confidentiality statute that provides for notification of the contacts of an HIV/AIDS patient, such as a spouse or a needle-sharing partner. Statutory provisions regarding disclosure. In many states, disclosure is also permitted for the following: blood banks, organ donors, epidemiologists, researchers, correctional facilities, schools, HMOs, and insurance companies. Healthcare providers as well develop HIV/AIDS. The CDC guidelines require notification before an invasive procedure to the patient. It is important here to distinguish between disclosure before a procedure or after treatment, and the patient's ability to judge whether they wish to continue with the procedure. Statutory provisions regarding disclosure. Disclosure by court order. The privacy rule contains specific provisions for responding to a court order or to a subpoena. The covered entity may disclose PHI as limited by the order being mandatory. There is some question as to whether or not the name of a blood donor can be disclosed. If the agency does not, this may be construed as negligence on the part of the agency. Liability for unauthorized disclosure of HIV-related information. Civil and criminal liability occurs for the unauthorized disclosure of HIV-related information. The common law allows for healthcare providers to be sued if they disclose HIV/AIDS status without permission or authorization. Recommended policies and procedures. It's often quite a very difficult task to balance the duty to protect third parties with the duty to protect the individual with HIV/AIDS. In all entities, covered or not, clear policies should be implemented in order to provide guidelines for the dissemination of information. It is particularly important to establish guidelines for those who review information such as utilization review or quality assurance personnel that contains information about a person's HIV/AIDS ARC status. Terms. There are two terms that you need to know and be able to tell the difference in terms of court actions. Discoverability. That's access to documents or witnesses by people involved in legal proceedings. Admissibility. Determines if documents, objects, or testimony can be used in a trial. Discoverability of medical records. Discovery is the pretrial access to records that might be of use to the parties in a suit. Discovery is accomplished by one or more of the following methods. You may request an oral deposition, court permission to view documents or other objects, written requests to obtain copies of documents, in-camera inspection of medical records rather than copying. The presiding judge reviews the records. Or you may request an interrogatory, which is a written list of questions given to parties and witnesses. Statutory provisions regarding disclosure. Release of information may be required for the following reasons. Court order, a subpoena, patient authorization. The custodian of the records may also be required to testify as to what is in the records. Federal or state fraud investigators may appear without advance notice and require compliance. All covered entities should have policies and procedures in place on how to handle requests for PHI. Statutory provisions regarding disclosure. Non-HIPAA entities must comply with the rules and regulations of their jurisdiction, usually the state in which they reside. The entity is multi-state. They must comply with the state in which the building resides. HIPAA entities must comply with HIPAA regulations. Procedures of the entity must comply with the legal and ethical guidelines of the healthcare professional. Physician-patient privilege. The privilege of confidentiality may preclude the medical record from admissibility in a court case. The physician-patient privilege is based in common law. It was established in order to allow the patient to give the physician as much information as possible without jeopardy. Regulations vary by state as to who is covered, the scope of the privilege to prevent disclosure, the extent of the privilege, and the nature of the proceedings in which it may be raised. Physician-patient privilege continues. In most cases, a medical record may be examined, especially in camera, without disclosing confidential information. The patient may also waive the physician-patient privilege expressly or impliedly. The physician-patient privilege may be superseded by the right of the public to know or the public's interest. Admissibility of medical records. As a general rule, medical records are admissible. However, they must meet the following criteria first. They are relevant to the case, either proving or disproving the issue. They are material to an issue in the case. They are competent. That is, they are fit and appropriate proof. Medical records is hearsay. Hearsay is defined as an out-of-court statement that is introduced into the legal proceedings for the purpose of proving the facts of a case. For the rules of evidence, a medical record is hearsay. Business records are not considered hearsay. Medical records as hearsay continues. Any out-of-court assertion is considered to be untrustworthy and inaccurate. There are some exceptions to this general rule, and those are declarations against your own interest, a spontaneous exclamation, statements made for medical diagnosis and treatment, a dying declaration, and an admission of a party. Other healthcare documentation. Hospitals may find that there are other documents that need to remain confidential. Some of these are the following: incident reports, peer review records, risk management data, utilization review reports, and credentialing files. Generally speaking, these documents are discoverable unless otherwise specified by state law. Peer review records. Peer review was established to help provide quality assurance in the medical field. What constitutes a peer review record will be determined by individual state statutes. A peer review record may include any record of quality review that occurs around a given incident. Peer review records may not be discoverable and or may be exempt by law or be considered hearsay. Incident reports. An incident report is typically a document that is sought during discovery. It may also be exempt from discovery under the attorney-client privilege. This depends entirely on state law. Incident reports constitute hearsay evidence and are inadmissible as evidence unless they fall within one of the areas of the hearsay rule.